Please the court, Gerald E. Wells of Lawrence for the appellant in this case. Chief Justice, I would request 3 minutes rebuttal.
3 minutes is granted.
Thank you. The Court of Appeals in this particular case rejected the claim of Mr. Stovall that his trial attorney was ineffective because Mr. Stovall, in the language of the Court of Appeals, failed to establish a complete breakdown in communications between Mr. Stovall and his attorney, thus leading to justifiable dissatisfaction with the performance of trial counsel. They use as their sole...
Excuse me, counsel. That's the holding as to the problem at sentencing. That's not the holding as it relates to the two conflict of interest motions that were trying to be used for new counsel for purposes of trial. And I think what the Court of Appeals said as to those first two was that the defendant had failed to address in the brief that the conflict of interest that was alleged adversely affected counsel's performance at trial. Now, where did the Court of Appeals get that part of it wrong?
Well, Judge, I think that we attempted to establish that in fact that we did get it right in terms of showing the Court of Appeals that the actions of defense counsel, although vague and admittedly, we didn't have the kind of evidence that was shown, for example, in the Tony case or other cases of that kind, to show the court that there was a justifiable and objective reaction to the ineffective assistance of counsel issue. Now, our problem with that, Mr. Stovall's problem with that, is that those kinds of issues, again, are more subjective than not. And there was shown, obviously, a factual presentation by not only Mr. Stovall on his own behalf through letters that were written to the court, but counsel also experienced dissatisfaction by showing the court that there was, in fact, a legitimate complaint, that there was a total breakdown in communication. At the time, there were 3 motions filed to withdraw. And those 3 motions were waived off by the district court, despite the fact that there was a conversation between trial counsel and the disciplinary administrator of this court, and the disciplinary administrator of this court indicated that there was, in fact, a conflict of interest.
And I understand all that. I'm trying to focus your attention on the defendant's trial. And where can you show me that the conflict of interest that was raised in the first 2 motions adversely affected counsel's performance at trial? Where is that in your brief? Because the Court of Appeals says it's not in your brief.
Well, obviously we disagree with that. I think it's shown by the fact that trial counsel told the district court, we've had a total breakdown in communications, Mr. Stovall and I.
That was after the trial. Those communications were made after the trial, and they were part of the argument as to why there should be new counsel at the sentencing.
Well,
I'm trying to focus on the trial.
All right. There was a motion made that there was a conflict between trial counsel and Mr. Stovall because there was a witness, a potential witness.
And I know that's the allegation. I'm just trying to say, where does this alleged conflict of interest, just assume it exists, where does that adversely affect the performance of counsel during the conduct of trial?
Well, I guess objectively saying this, because I think in all candor, I think this is what we have to rely upon. And that is the fact that here was counsel who, I think there's reason to believe that their communications was deteriorating from the beginning of the trial and from the beginning of their relationship. And yet, there doesn't seem to be an acknowledgement by the district court that such communications were eventually broken. And under those kinds of circumstances that raised that kind of distrust on the part of Mr. Stovall, I think that permeated the trial. Now, I can't give you objective reasons because there was no, for example, failure to file a motion because there was a conflict of interest, as in the Tony case, I think it was.
Counsel?
Yes.
You started to mention the fact that there was this potential witness.
Yes.
I think this was the second motion to withdraw where counsel said that she had a former client that she anticipated Mr. Stovall would want her to call in order to cast blame upon that client, or potential blame. And that witness did not get called to trial, correct?
That's correct.
Does the record tell us anything about why that witness did not get called at trial?
No,
Okay.
it doesn't. And I suppose that part of that I can point to is there was mention by trial counsel of reasons that she wanted to withdraw that were privileged communications. So I think that might have covered that, but we don't know.
I think that was in the first motion. I'm focusing on the second motion because I believe my colleague has asked you if there's any objective evidence in the record that there was actual prejudice to your client by, or a performance, not prejudice, but a performance
Adverse
problem.
effect.
Yeah, adverse effect, thank you. And so I'm just asking whether we have anything other than her initial statement that she would have a conflict calling that witness, since he was a former client, and the fact that the witness did not end up testifying. We don't have anything other than those two
No,
things.
I don't know the reason for that, Judge.
Okay, we don't know whether that
No.
reason, for example, came into being, that she did not call that witness because he was a former client. We just don't know.
Right.
Okay.
If the witness had been called, that would pretty well establish that there was no adverse effect to Mr. Stovall, albeit the Mr. Pasha, the former client, may have been betrayed or harmed by his own client, but that would not have been an adverse effect on your client. The adverse effect on your client comes from the not calling the other witness.
Well,
point a finger
presumably, Justice.
And that's what we don't have, and I think that's part of what Justice Biles is asking you. Are you expecting us to make that leap ourselves? That to say that the witness was not called because of the conflict that Ms. Sewell laid out, which obviously she was between a rock and a hard place. Once the judge said, you have to stay in here and either not zealously represent Mr. Stovall or betray your former client. But we don't know for a fact, or it's not in the record, that she actually did either one of those.
No, there's nothing in the record to show that.
But more pointedly, counsel, you don't claim in your brief that the failure to call that particular witness, Mr. Pasca, was a result of the conflict of interest and therefore an adverse impact on the counsel's performance.
Well, the problem is the record just doesn't say, either yes or no on
Right.
that question.
But you don't claim it.
No. Other questions?
I see no more questions. You have any further presentation?
No, I don't. Thank you.
We'll see you on rebuttal. Thank you, counsel.
May it please the court, Jackie Spradling appearing on behalf of the state of Kansas. I gave Miss Green my card if that's helpful to the court.
Would you agree with the second motion with the witness, Mr. Stovall's uncle, that Ms. Sewell said that she could call to explain why this young child would have acted out or known about sexual things that a young child shouldn't have, which would have been a pretty important witness for someone charged with child abuse? Wouldn't you agree? I mean, it would be exculpatory evidence, or at least help to be able to get out from under that argument. Why does this child act out, and why does she know?
Yes, Your Honor, I agree that if there was a second party or another potential defendant that could explain the acting out of the child, that would be important evidence for the jury to hear.
And once that Ms. Sewell explained that circumstance to the trial judge, what makes me shudder is, having been there before and ordered to continue, you not only have a rock and a hard place, you have to commit an ethical violation against a client.
Yes, sir.
Either not zealously represent Mr. Stovall or betray the former client.
Yes, sir.
And at that particular point, why do we have to say it's an adverse effect? I mean, why does Mr. Stovall have to prove? Because you have undeniably conflicted counsel at that point, do we not?
Yes, sir. Here's the answer to your question, Your Honor. We don't have to say that there's an adverse effect because we never reached that. And the reason we never reached that question is because Mr. Pascal's occasion to be called as a witness is not cleared in the record. We don't know whether Ms. Sewell wanted to call him and elected not to because of other reasons. We don't know if she wanted to call him but could not because of the ethical position she was in. And the record is unclear.
But what we're talking about is the denial of the motion to withdraw.
Yes. And
at the time that it was offered, what the judge had before him was a conflict that was without resolution unless it would turn out that the witness wouldn't testify as believed, or there's some other thing that you indicate that might. But the judge says, hey, I'm going to take counsel as being a good officer of the court and believe what she told me. Isn't that what the judge said?
Yes, sir.
And he says, but I'm not going to do it because this is a day of court and I don't want to mess up my schedule, and I want to go forward. And, the judge didn't say, well, the witness might not testify that way. So I'm just having a problem at that point why it wasn't error not to grant the motion to withdraw, why you have to wait until trial, until this attorney makes the choice of which client to betray.
I understand your question, and the answer is potential conflict is not the same as conflict. And we can't say today...
But this isn't potential. If everything she said is true, then that's not potential, that's an actual conflict.
And I'm going to disagree to the extent that we do not know that she was going to call him, that she had service on Mr. Pascal, that he was going to testify as represented. He would not be the first witness to be offered with an expectation of one testimony and indeed give something very different. And then I would also submit to you how you offer Mr. Pascal as a witness to say he used to babysit this child many years before without any evidence that he'd been around the child recently, that the child started acting out only after Mr. Pascal had been around the child.
Those would be all wonderful arguments if the judge had relied upon that, but the judge didn't. He just says, I recognize your problem, but I can order you to stay in anyway.
Yes.
And I don't want to delay my trial, so I'm ordering you to stay in anyway.
Yes, and I share the frustration that the calendar, the district court's calendar, is an insufficient reason to order someone to continue. I'm not, however, willing to extend that to a finding of conflict, because I don't believe that that's been established in the record, and I don't believe that a potential conflict is the same thing as a conflict. And a potential conflict is insufficient for a reversal in this case. My arguments to the court today are that the defendant has failed to show that there was an actual conflict of interest, has not established that there is
How could have, on the first claim anyway, how could have the counsel shown that there was a conflict when she was not permitted to really address it, and the court kind of said, I am assuming there's good cause to withdraw, but I'm going to deny it? Did she ever really get a chance to articulate, even in chambers or anything, the nature of her request to the court?
I do believe that she did, because the district court asked her the nature of the conflict, and Ms. Sewell's response was that it involved privileged communication. And while she does have to hold to the privilege as recognized in attorney-client, it would not be privileged communication if she made a statement of facts, a submission of what she expected Mr. Paschow could testify to if he was called. At the very least, if we're here making a decision on whether there's a conflict of interest, we ought to have those facts provided by the defendant through his counsel. And that was not given.
That's my question. Was she afforded the opportunity to do that?
Yes, sir. Yes, Your Honor, she was. The district court judge asked her the nature of the conflict, and she said it involves privileged communication. And I respect Ms. Sewell. I'm not saying anything. Right. But her answer was, it involves privileged communication, and though given the opportunity, did not expand on that. And there is obviously an opportunity to ask the state to go out of the courtroom and to give full or at least more detailed disclosure, which happened at the second request for withdrawal. So that opportunity was given to her, maybe not fulfilled as fully as could have been. There is no showing in the record below, nor any that I am aware of, that there was adverse performance of counsel at any point during the trial. What the defendant now argues is that there is presumed prejudice, and he argues that based on the Strickland case. The Strickland case, as this court is aware, is one where 3 capital murder convictions and the death sentence were upheld in a finding that there was not ineffective assistance of counsel, and also that there was an insufficient showing of prejudice. I would ask this court's consideration in finding that there is no record to find an actual conflict, in part because of Strickland, but also in part because of the record below. Though the defendant argues that Strickland lends a presumption of prejudice here, he does so without an actual basis. Even Strickland requires that there be an actual or a constructive denial of counsel altogether. That's not the case in the record below. It's not the case on the facts presented to this court. In addition, Strickland tells us that there are instances of a more limited presumption of prejudice, and that is when counsel is burdened by an actual conflict. There's no showing of an actual conflict. The record.
Ms. Bradley, can I direct your attention to the third motion of sentencing? And obviously there was the motion by counsel, but there was also a decision, as I understand it from the reading I've done so far, that there was a ruling on a motion for new trial for ineffective assistance that day as well.
Yes, Your Honor.
So we have a situation where, I'm going to the point you just made, that has to be an actual or constructive denial of counsel.
Yes.
At that point, we have the judge listening to both counsel and Mr. Stovall about their lack of communication up to that point.
Yeah.
They haven't spoken
Yes.
since trial, etc. You know what the record shows us about all of that. So it's pretty extensive comments by both parties that they're not talking to one another. They haven't planned anything for that day together, etc. But the court goes ahead and rules on that motion as a practical matter, she could not be representing him on the motion attacking her effectiveness at that point.
Yes, Your Honor.
So at least as to that motion, did you not have a constructive absence of counsel, at least, if not a denial?
We might. And in preparing for oral arguments today, I paused and was somewhat originally troubled by the third motion to withdraw because the state does want counsel to be able to communicate fully and completely with those that they are representing. And in the beginning, I was troubled by the fact that there had been no communication between the defendant and his lawyer. In reading the transcript closer, what I found was that the defendant was dissatisfied and therefore would not communicate with his lawyer because of the questions she posed to him while he testified at the trial, because of her questions she posed to the victim while the victim testified at trial, and that he had not been allowed to see trial exhibits before the trial began. All of those are not novel in complaints, but certainly formed his basis that he would not talk to Ms. Sewell. And if this court finds that the sentencing was a stage in the proceeding where the defendant was not adequately represented, I will understand that order, because I can see where there could be a finding of maybe not actual, but at least the imposition of a constructive conflict of interest because of the lack of their communication. I went back to Strickland in trying to finalize my arguments on that third motion to withdraw, and I saw that Strickland...
Excuse me, before you go on.
Okay.
No, I appreciate that comment, but I think that it goes somewhat beyond that on the motion for new trial, because they're actually adverse parties, aren't they? It goes beyond a lack of communication to their adverse parties on the motion for new trial based on ineffective assistance.
The one that Mr. Stovall filed for himself?
His motion. Mm-hmm. And that was ruled upon that day as well, right?
I didn't hear the last part of
that. That was ruled upon that day as well.
Yes, Your Honor. Yes, it was. It was effectively denied.
So would you agree with me that as to that motion, we have worse than a communications issue? We have adverse interests between client and counsel, not a conflict because of another client, but actual adverse interest between client and counsel.
The reason I'm going to disagree with you there, Your Honor, is because the defendant himself was allowed to argue that motion.
But unrepresented, with the state there in the courtroom with representation.
Yes, true. Although he did not, from my reading of the transcript, ask for a different lawyer on his motion for effectively 1507. He was given the opportunity, if he chose to make that argument himself, and my reading of the transcript is that he elected to do that. I hope that I'm not wrong, but that was my reading of the transcript.
Wasn't the district court's grounds for denying the motion for new trial because it was out of time?
Yes, sir. Yeah. And that the motion for new trial, that being pro se by Mr. Stovall, was indeed out of time. Yes, I'd forgotten that. Thank you. My final comments to you are that, again, focusing my preparation for the third request for withdrawal, I found that Strickland was directive in that it said that there is no presumption that the defendant can demonstrate that counsel was ineffective unless there is both an actively represented conflict of interest and, so both of them, an actual conflict of interest that adversely affects his performance. So I don't believe the potential conflict, and I don't believe a constructive conflict, either of those, would be sufficient to find for this defendant.
Just so I'm clear, you were citing Strickland?
Yes,
for
sir.
that?
Yes, sir.
Thank you. Any questions of counsel? Thank you, counsel.
Thank you, Your Honor.
You had reserved 3 minutes for rebuttal.
I'm going to waive rebuttal, Your Honor. Thank you.
Do we have any questions before he sits down? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. And that concludes this week's docket. At this time, the court is adjourned.